to talk here for a minute. I'm waiting for Ship and King to come on to the scene here so I can invite them to be co-hosts. If you can hear me, then wave at me so I can see you. Or put a comment in the, or an emoji in the, like in the comment chat part of the spaces. I'm using my computer and headset again tonight like I did last time. I'm not doing it on my phone. All right, Kingmaker says he's ready. King, I don't see you yet in there, so I can't invite you to be a co-host yet. As soon as we get Ship and King plugged in here, then we'll get started, you guys. We're going to talk tonight about the insanity that took place in Georgia's courtroom this week, the Hunter Biden verdict, and also a little bit about the bump stock case in the Supreme Court that came out today. All right, no sign of Ship yet. Ship, I see you on Twitter. You tweeted something 4 minutes ago, so I know you are on this app, but you're not in my spaces. Okay, I'm going to put everybody on mute for a second while I get these guys to join in. Hold on. Okay, Ship and King, can you guys hear me?
I can hear you.
Great, that's Ship. King, can you hear us?
Yes, indeed.
Fantastic. All right, we're all here. Wonderful. So, I was telling the folks what we're going to talk about tonight. We can talk a little bit about the bump stock case, which I assume we've all looked at. It seems like we've been commenting on it. And about the insanity that happened in Fulton County, Georgia this week. And then obviously we want to talk about Hunter Biden's verdict and some sentencing issues there.
Let me jump in for a second. If you continue to disrespect your husband, leave him down there just a listener. He's probably going to depart.
No, I specifically asked him if he wanted to join in. He said he didn't think he had anything to contribute this evening. So,
wait. If that slowed us down, we lost quiet space.
We lost King. I'll have to invite him again. No, what slowed us down was you were nowhere to be seen, my friend. I was defaming you while you were not on yet. I'll have you know. Okay, let me invite King again. We lost him as a host somehow. Hopefully he'll pop back up here. Okay, yeah. So, but no, Steve wants to listen tonight. He's been busy today, Bill, as you should know.
I think I have a pretty good guess.
Yeah, and also we've been busy packing and dealing with contractors and our real estate agent and on and on and on and on for the move that we're making. So he's had a full day already. All right, while we're waiting for for King to come back on.
I see him. He's back.
Is he as a co-host though?
No, he's a speaker.
No. Yeah. Let's see. All right, let me send him another invite. I don't understand why this co-host speaker thing is so difficult. Yeah, it's a good idea, but it doesn't work very well.
If Elon wanted you to understand, come here and explain.
Right. All right. I'm going to send him an invite to be both a speaker and a co-host. Sometimes if you become the speaker first, then it lets me shift you over to co-host and then it sticks. So I don't understand it, but it is what it is. All right. So there he is. All right, King, can you hear us now?
I could hear you before. I hit something or something happened and I got booted off.
You got booted off. Okay, so I just sent you another invite to be a
And then
co-host.
I saw it and it disappeared while I was speaking.
Yeah, I just now sent you another one, so it should be coming again.
It came already and left.
Well, I sent you several of them, so it probably will
Okay.
come again. All right, let me send it to you again. All right, so jump on that if you can, because I feel like the platform is more stable when we're all hosts. Okay, so but let's get started here, you guys. All right, we're going to talk about, as I said, the bump stock case that came out in the Supreme Court today, Hunter Biden's verdict and some sentencing, and then the insanity in Fulton County, Georgia. So, should we do the bump stock first since that happened today? Did you guys look at the opinion?
I did.
I looked at enough of it. It wasn't really that complicated if you sort of understand those gun
If you can
statutes and gun
read,
regulations. Yeah.
if you can read, it's not that hard. Okay, you guys. So what happened was, King, go ahead.
Well, no, you describe it, but I gotta say,
You're gonna say.
I've got a king story to
Oh
go with it.
no. Okay. All right. So basically, after that shooting in Las Vegas, the Trump administration at the time, ATF, passed a regulation that said bump stocks were made semi-automatic weapons into machine guns, which they don't, but that's what they said, and therefore they could be banned. So they banned bump stocks, and actually, I think 17 states did as well. So that got challenged. Now, for folks that don't know, in order for an executive agency regulation to be legal, it has to be based on some power that the agency has to issue that regulation, which principally consists of, and may 100% consist of, but I'd have to think about that for a minute. But it principally consists of power that's given to the agency by statute. So the Congress writes the statutes, the executive agencies can do regulations within the power that's given to them from the statute. So the statute says that a machine gun is a weapon basically that can be, that will fire multiple times upon a single pull of the trigger. I mean, that's pretty clear. If you can speak English, I don't understand how that's unclear. But and the bump stock does not do that. It allows the weapon to be fired more rapidly, but it still is actually pulling the trigger more than one time, right? So to me, this is not that complicated. But the ATF decided because, as we all know, the public pressure in gun cases sometimes causes these agencies or government officials to react to the situation rather than to what the law is. And so they passed this regulation. And the Supreme Court today said that the ATF did not have the authority to issue this regulation because it doesn't comply with the statute. The statutes trump regulations. The Constitution trumps both. So, and Justice Alito, in his, I think it was concurrence, said, of course, the case was 6-3, 6 justices in the majority striking down the regulation, 3 justices, the 3 liberals, dissenting. But Justice Alito had, I think, what was a concurrence basically saying, like if you can read this statute, you can see that this doesn't meet the definition. And the obvious and easy answer here is that the Congress can amend the statute anytime they want to and include this if they want to. And oh, by the way, maybe they would have done that already if the ATF hadn't instead passed this unlawful regulation. So that to me, I had tweeted this out this morning. This is obviously a victory for the Second Amendment, but more importantly, I think it's an important case for the question of reining in the power of the executive agencies. Too often, even the appellate courts are not doing that. And you see these 3 liberal justices, they don't want to do it either. They want to say it's close enough, and Justice Sotomayor in her dissent has this, what I think is absurd thing where she uses the, if it looks like a duck, if it walks like a duck, if it quacks like a duck, then it's a duck. She uses that rhetorical device. But I think the problem here is that the issue in this case is that it's not a duck, it's a chicken, and calling it a duck doesn't make it a duck, it's still a chicken. And so, I said on Twitter that probably City Girl should not be using farm animal analogies anyway, because she apparently doesn't understand them. But, that's exactly the rhetorical device that you would use to illustrate that she doesn't understand what the real problem is, which is what when I used to work for the government, we used to call close enough for government work, right? But it's not good enough for constitutional or statutory interpretation for judges to say, well, it's close enough. That's not how it's supposed to work. So that's what happened. Fortunately, the 6 other justices agree with that, and they struck it down. So now we'll see what the Congress will do. So, Ken, go ahead. Tell us what's your story.
It may be too long, but it's
All right. Can you set yourself to faster timing?
I will try. Yes.
Okay.
During my career as a litigator, I've had a couple of cases involving uh, machinery issues,
Mm,
machines that broke and whatnot, and I was fascinated by that. And then late in my career, I said I'd like to see some more, and nothing was coming around. Uh, so I talked to somebody who told me you ought to try patent law, and I threw that out to law partners and colleagues and whatnot, and they said you're crazy. It's too detailed and too
arcane. Yeah.
specialized and arcane, and nobody who's not a patent lawyer from the cradle can do it. And
Right.
I said, bullshit.
Right.
Engineers do patents, and 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 the only thing engineers can do better than me is fold a map. So so I took some seminars on patent law and learned things like Markman hearing, and I learned and I got some patent cases and did pretty well with them. Tried some, uh, got all the way up to the federal circuit, and won that, and learned about how to try a patent case.
Okay.
And one thing you patent lawyers know how to do that I learned along the way is embed mechanical drawings into your briefs,
Ooh.
and then write a you know craft language that describes what's going on in those mechanical drawings. And I opened up the link to the bump stock case written by
Really?
Justice Thomas, and damned if he didn't have mechanical drawings embedded in his
In the
opinion.
opinion, wow. I didn't notice that.
Yeah, oh, you can't miss it
Well,
if
I
you're a
mean, but
patent lawyer.
yeah. I mean, I saw the links and I'm like, yeah, whatever. Right.
Yeah.
So,
But if you look at those and read how he describes it, it's brilliant. The man,
wow.
I was thoroughly impressed. In plain English, he could describe. He gave you the mechanical schematics and diagrams of how triggers worked
Wow.
in various kinds of guns, and in plain English described how each one operated.
Well,
So
apparently
if
that
it,
wasn't helping Sonia. So,
yeah, so if there's no, it did not. Uh, he didn't have a picture of a duck. Uh, so if anybody on this is any way mechanically or inclined or interested in basically how do you describe to a layperson how mechanical devices work, look at that opinion. It's
okay.
impressive.
Yeah, you can find the opinions, you guys, on the Supreme Court's website. Unlike a lot of the other federal courts, the Supreme Court website is actually pretty easy to navigate and understand. But your story reminds me of when I was in law school and we took torts class. And you guys, torts is like, civil wrongs. So not criminal law, but civil law. And it's all the stuff people sue each other for, battery, defamation, all kinds of stuff, negligence. And the most frustrated people in the entire class, torts class, were always the guys, because they were all men, who were there, who were engineers, and they were there to learn to be patent lawyers. And, engineers are very precise, right? But law is not that way, right? Law is like concepts, and especially tort law. It's like the reasonable person. What would a reasonable person do? And what were the totality of the circumstances? And was X proximately caused by Y? Or were there intervening factors that meant that there's not causation? All of these ideas, right? And these engineering guys, they were so frustrated. And they would say to the professor, yeah, but what's the answer? And of course, there is no no answer in tort law. It's basically what would a jury do, right? So I felt bad for them, but obviously the world needs patent lawyers too. So they had to suffer through torts, and thankfully I didn't have to suffer through engineering. All right, King, have you got anything you want to say? I mean, Ship, you got anything you want to say on this bump stock case? Because I just thought this was pretty straightforward, and I was happy to see application of this is not how regulations go. This is not the way agencies are supposed to interpret regulations.
Well, actually, I think the most interesting thing. I mean, I think the outcome of that case was pretty much foregone conclusion.
Right, clear from the beginning. Yeah.
And it was a contest of between what the three minority justices want the law to be versus what the law actually is. And the one thing you didn't mention is that the opinion covers some is, in the immediate aftermath of the Las Vegas shooting, there were lots of proposed amendments to the statute that were, that were proposed or submitted in Congress.
Right.
None of them went anywhere because
they couldn't get enough votes for.
Nobody wanted to vote on it. Nobody wanted to vote yay or nay and incur the wrath of either the NRA, or I don't remember if the NRA was still an active force at that time, or the anti-NRA. The other side of the political spectrum. Nobody wanted to go on record. So at that point, Congress was all happy to let ATF do it by way of regulation. And reading some of the press clippings from the time, the Trump administration wasn't too unhappy either. I don't think that the Second Amendment is an issue that's ever greatly animated Donald Trump. I don't think he really cared that much, and it was a great public outcry over the shooting.
To quote unquote do something. It's always the same argument.
And it was an odd thing in that I don't think there was a widespread understanding of what a bump stock was for what it did.
Correct.
And that was obviously a brutal demonstration of what a bump stock is, capable of doing. And so obviously there was a rush to do something about it. Everybody decided they didn't want to vote. ATF stepped up and said, "Oh, we can fix this," and they did. And that started.
But this is an example of the problems that we have. Is that too often this is what happens?
But that leads to the next point.
Yeah, go ahead.
Is that the most interesting aspect of this? I believe is the case that remains to be decided on the Chevron deference standard, because it's the same issue.
Right, and that's a more difficult case than this one. So folks know, Chevron deference, there's a longstanding case at this point, it's called Chevron, where the Supreme Court said, basically when the federal judges evaluate an agency's regulations, they should give deference to the agency's interpretation of the statute. And the theory behind this is that the agencies are tasked with this area of law, right? Like the federal district judges don't have competence, and I don't mean that in a expertise. Yeah, that's a better way of looking at it. They don't have expertise in all these vast areas of law, especially if it is very technical, like the environment, right? Or like like this would be one of them. Like your average federal district judge isn't up on all the current weaponry that's available in the country, right? So the idea is that the agencies, because they are immersed in it every day, or like, the FAA, that kind of thing, they're immersed in it every day, that they have a body of knowledge to bring to bear, and that the court should therefore defer to that. And this might be a concept that is useful to a district judge in evaluating the agency's actions, comparing them to the power that the agency has in the statute. But what has happened is it's kind of the district courts have kind of said basically, well, then they're just abdicating their obligation to interpret the statute because they kind of just go along with whatever the agencies are saying. I think that they have misread Chevron, is what I think. That they've taken it way too far. They've abdicated their responsibility to interpret statutes, because it certainly can't be the case that the agencies don't have that their arguments can't have any sway with the district judge when they're in court defending their regulations, right? And it doesn't, even if we get rid of Chevron, it doesn't change the fact that the district court judges don't have any more expertise in these agency matters than the agencies do. They have a lot less expertise. So it's a very thorny problem but it has resulted in a lot of bad rulings. And obviously, the right of center has been upset about this for quite a while because it overly empowers the agencies.
Well, it empowers the activists who
Right,
become embedded in the structure of the agency.
right,
So
exactly.
as I understand, I haven't looked at it, but if my recollection is that the deference that's given is essentially if the agency's interpretation of the statute is plausible,
Right. Reasonable, I
then
think, is the word they use. Right. But go ahead.
then no, I think it's more than that. Um, then they defer to the agency's judgment as to the meaning of the statute in implementing rules and regulations. So the area of law where this has tended to be the most aggressive in the last 30 to 40 years is environmental regulation. So you
Right.
have the EPA, the expert agency in the field, essentially in many you know, liberal judicial districts, the judges have just turned over regulation of environment or the definition of environmental regulations to EPA. Whatever EPA says goes, and EPA is you know the the home field of the most radical tree huggers in the
Right.
government.
The true believers. Okay. So
It,
the
it,
word that
it,
Chevron uses is permissible, which they have then defined to mean either kind of rational or reasonable. But the word in the opinion itself, ship, is permissible. King, what were you going to say?
yeah, the extreme example of what Ship was talking about is the EPA has deemed that a molecule that is essential to life on this planet as we know it, that all living things die without it, CO2, is a pollutant.
Yeah, so
Right.
CO2 is a pollutant, right?
Right. Yeah. No, that's craziness. Right. So, I mean, the one of the reasons that the courts kind of came up with this is because you prior to Chevron, you had a different problem, which is that some district judges or some circuits, when they would interpret a statute, they would interpret the statute in a way that was in line with their political or ideological agenda, right? And if the agency, like say the Republicans take over the White House and they take over the administrative agencies, and then they're having to defend all of their regulations in front of liberal judges. If the liberal judges just didn't like the interpretation, then they would say, well, that's not consistent with the statute. And so Chevron was an effort to try to prevent this falls under the heading of, be careful what you do to fix things because you can be creating more problems than you're solving. But people, I think, have forgotten that it was an effort to try to undermine the power of activist judges. So instead, we've shifted the activism to the executive agencies, which is probably worse, to be honest, than activist judges, because at least then you have some appeals you can take up. But an activist agency, you can see from this bump stock case, when did they pass that regulation? When was that shooting?
2018, or the shooting
Right,
was 2017, and the regulation was passed in 2018
right,
after
exactly,
several
exactly.
failed efforts to. Yeah, and what was also interesting about that, I didn't mention, is part of the reversal in the district court, or maybe it was Fifth Circuit, that invalidated the regulation was they called attention to the fact that ATF previously had a definition of a machine gun that didn't include bump stocks.
Right,
In fact, ATF just changed its position on what a bump stock was 180 degrees.
right. So the statutory definition didn't change. It's just their opinion about what fell within that definition changed based on this event rather than any change in like technology or anything like that. Right. So, yeah.
And that is where Justice Thomas's me- mechanical diagrams and explanations come to play. He described various kinds of trigger mechanisms
Mhm.
as and then discussed which ones fit the statutory definition
Right.
versus which ones didn't.
Right. And that's the analysis that the district court should have done. Right. So, something that I'm seeing that I'm not liking in a lot of these cases that we've been talking about that have come out the last year from the Supreme Court is you see the Supreme Court having to basically do the job that the courts of appeals used to do, which is reining in district judges that are just doing their own thing as opposed to applying, the law or applying any coherent theory. But we've progressed to the point where now the Supreme Court has to make rulings that should have been obvious to the district court judge that was handling the matter, much less the circuit court of appeals that was in between. Right? I just see this as becoming a huge problem. Because the Supreme Court does not have enough resources, time, or docket or whatever to fix all of these problems. That's not really what they're there for.
I think we need a bigger court.
Yeah, I actually think I have a proposal for this. I actually think we need another layer of appellate courts in between. And we also need to change some of in my opinion, we need to change some of the jurisdiction for the district courts to narrow down the cases that they actually handle. Because they're overwhelmed. And they can't even get to, in a timely way, issues like this that are actually important. It takes years to get this far, which is not acceptable either. So the federal court system, I think, needs some major reform. But the ideological problem is obviously a trickier nut to crack. But I feel bad for the Supreme Court in a way because, like, you see how many of their opinions are unanimous every year. Lots of them, right? And you're like, how can all 9 of them have agreed that this is the way it goes, and the circuit courts of appeals judges can't figure that out? What is wrong? What's going on with that?
So you're suggesting that the jurisdiction of the federal courts be narrowed some so that they can work on more important cases, and then there's always the state courts to fall back on.
Right, exactly. Right, because I think
great work gets done in state court.
Right. The diversity jurisdiction should be cut way back. Like, you can get into federal court now if you demand more than $75,000 in damages. That's absurd.
Yeah, that number's way too low.
It's way too low. It should be like 75 million is what it should be, because I don't understand how the state courts can't handle those cases. It's crazy.
I think it was $25,000 last term.
Yeah, no, it was up, or 15 or something like that. No, it was absurd. And, because the federal courts they have to handle all the immigration stuff. They got to do all this diversity stuff, the criminal docket.
Why don't you explain diversity jurisdiction?
Okay, so in federal court, you can get into federal court 2 ways. One is if there's a federal question, and which means there's a federal regulation or a statute or a provision of the Constitution, and the case involves the federal law in some way, basically a treaty, could be any kind of federal law. And the federal courts have jurisdiction, obviously, over federal law. But the other way you can get into federal court is if you sue someone, I'm really, really boiling it down, you guys, if you sue someone in a different state from you, okay? And there's rules that go along with this, but that's the basic idea. Now, the old idea, and it also has to be over a certain amount of money, which at the moment is $75,000. The idea was that if you're from Mississippi and something happens to you in Massachusetts and you go to sue the person in Massachusetts, are you going to get a fair hearing from a Massachusetts judge if you're from Mississippi, and vice versa, right? So in order to, and especially at the beginning of the country where people were it was a lot more regionalization, right? The states were more suspicious of one another, so forth. It made sense that the federal courts would handle substantial lawsuits between citizens of different states in order to ensure a certain amount of fairness as a national country. Okay, I'm on board with that principle, but I just think that any person who can sue another person in a different state for only $75,000, I fail to see how that rises to the level of national importance. So, but it's by inertia, it's just rumbled along that's what the number is. You're right, Ship. It was raised at one point, but I still think 75,000 is too low. I see no reason why the state courts can't handle cases where that's the kind of level of importance we're talking about. So, but the federal courts, they are taken up with federal issues. Immigration is a big part of their docket, and criminal cases, of course, and agency cases. They need to be hearing those. These are the cases that actually are important for the nation, right? The interpretation of federal statutes, the application of federal regulations, the application of the federal constitution. That's what they should be focusing on, but that's not what's happening. So I also think there should be an intermediate appellate court between the circuits and the Supremes to resolve circuit splits, to refine that issue faster, so that the Supreme Court doesn't have to wait for 7 or 8 circuits to go different ways, because you just end up with not enough uniformity across the country when different parts of the country decide the case different ways. And the Supreme Court doesn't even have enough bandwidth to decide all of those. And there are lots of important issues where those circuit differences just go unresolved for years. So, but this is a hobby horse that I have, so we can talk about that. I have a document that I'm working on that's identifying various things that are wrong with the federal court system, that probably after we move, I'm going to be able to actually devote some time to and publish it. I'm hoping by the end of the year, but maybe next year, that things that just need to be worked on, that are causing the system to go askew. So enough of that. So let's turn to what happened in Georgia, and then we'll end with Hunter's case. So, King, were you following that? I didn't talk to you much this week because I was so busy with my move.
I uh, off and on I did. I got the gist of it. It's wild.
Right. That was craziness. Okay, so folks know what happened. This rapper, I guess he is on trial in Georgia. And I'm interested that the right of center's been interested in this guy's case. His name is Young Thug, I think. And you guys, am I right that really the reason we're interested in it is because it's another RICO case being prosecuted by Fannie Willis's office? Is that really
Yes,
what's going on?
yes, and it and
Yes.
it took 10 months to pick a jury.
Right. And they've been putting on evidence for 6 months. And
Right.
apparently they had 200 witnesses on the government's witness list, and they're only about halfway through. Okay. So
Just
go ahead.
by way of explanation, RICO cases are inherently highly complex.
Right.
They are hard to present to a jury. And from reading from afar, I don't think Fannie Willis's office is doing a very good job of it, uh, because it's taken far too long. They've gotten lost in the weeds. They've probably long ago lost the jury,
Yeah.
and
I can't even remember what I did 3 weeks ago. Can you imagine trying to remember evidence from 6 months ago?
no,
and
I
and
can't.
it is, you see little bits and pieces of it. Just seems to meander.
Yeah.
It does not. And this is kind of, I think we've all seen this in state courts as compared to our experiences in federal courts. They just don't seem to have any consistent forward momentum, propelling the narrative along and looking for the conclusion.
Right. Unless you're in Virginia. This case would have been, 3 weeks and over in Virginia. So, all right. So this guy's on trial on this RICO, which is basically a conspiracy. And as King said, it's very complicated. That's why it's long and involved. And so a week ago today, a witness, the state called this guy as a witness. His name is Little Woody. That's not his real name, but that's what we're going to call him. That's his street name. And he didn't want to testify. So he got subpoenaed as a witness. I don't know if he had a lawyer before that Friday or not. This is unclear to me. But he didn't want to testify. So he said he was going to assert his Fifth Amendment privilege not to testify. And so you guys know you can assert your Fifth Amendment privilege not to testify as a witness in a case if you legitimately think that something that you say might incriminate you, and nobody can compel you then to testify about whatever that topic is. But there is a mechanism for forcing people to testify about things that they otherwise might be incriminating themselves on, which is called immunity. And most states, Georgia's one of them, have statutes that say that the prosecutors can give statutory immunity. Can you guys hear me?
Yes.
Yeah, okay. It went quiet there. So I wanted to make sure everyone could still hear me. So most states have statutes that say prosecutors can give immunity to witnesses. And basically what happens is this, I'm boiling it down, making it simple. The state promises that they're not going to prosecute you for whatever it is. And because they have said that they're not legally, they're saying that they're not going to prosecute you, that removes your legitimate fear that you could be prosecuted because they've contracted not to prosecute you. And therefore, the court can then compel you to testify, even if what you're saying incriminates you. Now, can they actually make you talk? No, nobody's going to, beat people with a rubber hose to make them talk in court. But legally, it means that you do have to provide the testimony. And if you don't, then the judge can find you in contempt and can jail you for failing to, cooperate with the legal proceeding. Okay, so this witness has been on their witness list for a long time. And what I'm gathering is that he had not previously, I don't think, told them that he didn't want to testify. Or maybe he's changed his testimony. I'm not sure. But in any event, last Friday, it just occurred that he said he was going to assert his privilege. And so the judge didn't think that was something he could do. So he jailed this guy, this little Woody guy, over the weekend. And then they had a meeting in the judge's chambers between the judge, this witness, his lawyer, whom I think the judge appointed in the meantime, and the prosecutor's office. But they did not invite or even tell the defense lawyers that this meeting was taking place. And at this meeting, basically, they talked to this witness about, you have to testify. You don't have a choice. The judge can hold you in contempt. He can lock you up until you change your mind and decide that you are going to testify. And prosecutor said, we got all these defendants on trial in this case. This could be months and months, and you'd be locked up this whole time. Basically, to let's say encourage this witness. The defense lawyer said this was coercing, but
Twist his arm.
twisted his arm to get him to actually provide the testimony. Okay, and they did all of that. The defense was not there. They did have a court reporter there who was taking it all down. All right, so the defense lawyer somehow found out about it.
Except, Leslie, I
Yeah,
think from what I've read, the best I could gather from everything I've read, it was the judge who told the witness, look, if you don't testify, you're going to be in jail throughout the rest of this trial
right,
and throughout the rest of the next trial
right.
until we have tried all the
All these
remaining,
people. Yeah,
all these people.
right. And the government was saying how many of them there were and how long that was going to be. Right. So they sort of were tag teaming him. And then the witness ultimately decided he would, in the face of all of that, he decided he would testify. Okay. Well, the defense lawyer found out about this meeting, and I thought it was hilarious.
Now, this may have only come up in court, but I think there was one of the things left out. And
Yeah.
skipping ahead, or maybe you intend to cover this. The witness said, I think he had an immunity agreement already.
See, this is what's unclear, is whether it was before or not.
He didn't want to testify. And
Right.
He was, and the prosecutor took him before the judge, saying, look, he has we've already agreed
Right.
previously when he was giving interviews.
Right.
He was given immunity to basically be a cooperator. And what he said in the conference, in the closed door hearing, was he just lied. If
Right.
he put on set, he would just lie. He would not say the defendant shot the people in question. He would say he shot the people in question.
Right. He was going to take responsibility for some of the charges against the defendant. Right.
So, in the government's position is that would be perjury. So not only was the judge telling him that he would sit in jail if he didn't testify, they weren't in fact telling him what they expected him to testify to,
based on what he told them before.
Exactly.
Right. Yeah, exactly. Okay. So all that happened, and then he gets up on the witness stand. Okay. But in the meantime, the defense lawyers find out about this meeting. And so this defense lawyer, I think his first name is Bruce, his last name is definitely Steele. He raises this with the judge and says, all right, I heard about this meeting and I want to, know about this because this looks to me like witness intimidation and coercion and ex parte communications with the court. Now, what that means is ex parte means only one side. And it's against the rules for lawyers to have ex parte, one side only, communications with a judge in the middle of a case. because the whole way that our judicial system works is that it's a antagonistic system. The judge is a neutral. Both sides present their arguments to the judge, but you don't do that in secret. You make your argument and the other lawyer gets to hear it, and then they get to make their counter argument, and then you get to make your reply. So you don't have secret communications with the judge. It's forbidden. There are exceptions, of course, but in a criminal case, when you're in trial, there are no exceptions that I'm aware of, because the Supreme Court has said that you have a right under the Sixth Amendment to have counsel present for every critical part of your case, and certainly your trial is a critical part of your case. Now, there's cases saying that other things are not a critical part of your case, and therefore the Sixth Amendment doesn't reach that far. Like, I think everyone knows, you don't have a right to have your lawyer in front of the grand jury, at least not a constitutional right. Some places have provided for that by statute. But so some things are sort of on one side of the Sixth Amendment line, and some things are on the other side. So
There's another element here.
yeah, go ahead.
That is, you have a witness he had already taken the stand. He was
Right.
under oath.
Yeah.
And the rule is, once a witness starts to testify, nobody, not the lawyers, not the judge, not friends and family, are allowed to put pressure, try to intimidate, try to do anything to change that witness's testimony.
Right. Now, there's exceptions to that too. So, like, if it's a long break, the defendant can work with his lawyer, like, over the weekend. There's actually cases on this because people raise problems with that. But in general, King's right. So, right. So the government lawyers are trying to talk to this guy outside the presence of the defense lawyer, but with the judge there, about what his testimony is going to be. But he's already gotten up on the witness stand, and he's a live witness. He's already raised his hand and taken the oath.
But there's also a fine line between going over what a witness's memory is and what he's going to testify to, versus squeezing him and twisting his arm
Right.
to modify his testimony.
Right, exactly.
That's the line.
So there's like 25 different problems with this with this meeting in the judge's chambers. But then when the defense lawyer is raising those, because he's hitting all the buttons, right? He's like, this is, inappropriate ex parte communications. This is intimidation. This is interference with his testimony. This lawyer knows what he's talking about. He raised all those issues. But the judge immediately said, you're not supposed to know about that meeting. Who told you about it? He didn't want to answer any of these allegations that the lawyer was making about this is all inappropriate. No, the judge's thing was, you're not supposed to know about it. Which I was like, whoa, this is the defense lawyer. This is insane. This is insane for a judge to say to a defense lawyer, you're not supposed to know about something that's going on in the middle of your client's trial. That can't be. So now, come to find out, you guys know this, there's a case from one of the Georgia Courts of Appeals. The case is called King, which says that immunity statute, that the immunity proceeding, where to do the immunity, because it's by statute, the government basically goes to the judge and says, we want to immunize this guy, and the judge rules on it, and there's requirements for it under the statute, blah, blah, blah. The witness can have a lawyer to help them with that. But this case says that the defense and the defense lawyers are not a part of that procedure in terms of granting the witness immunity. Because the cases say, I don't know if I totally agree with this, but the case does say, because basically the defense doesn't have a dog in the fight as to whether or not the state should give immunities to specific witnesses. Once they do give the witness immunity, the defense can use that to cross-examine the person with and question their bias, because maybe people are testifying and saying things that aren't true because they've now got this deal with the government that is going to get them out from under any charges that they might have. So, but the case does say that, as part of this procedure, statutory procedure to determine if the witness has immunity, that the defense does not have a role to play in that. So once I saw that case, I thought, all right, well, okay, so I understand what the judge is thinking, but it can't be that continues into the trial.
Yeah, I've seen that procedure, and I've been in cases where the government cut an immunity deal, got it approved by the court, but I've never seen it happen in the middle of the witness's testimony.
Right.
It always happens pre-trial.
Right. Right. So Ship, to your point, it was unclear from the public reporting whether that witness already had been granted the immunity or whether that's what they were doing that morning. So if that's what they were doing that morning, it makes more sense that the judge was saying the defense can't be a part of that. But I still think it's a problem that they're doing it after the trial has commenced and the witness has actually taken the stand, and that you're at that point you're still excluding the defense even under the statute.
But another point is this dialogue went way beyond, yes,
Right.
witness, you now have immunity, and I order you to
And
testify.
here's how that's going to work. Right. Yeah. It
Yeah,
went way
yeah,
beyond that. Yeah, it
it
did.
went way beyond that.
Right. So the judge flipped out basically and was demanding to know who this lawyer got this information from, because he's considering this to be a violation of the statute, I guess. And because the defense lawyer then would not tell the judge who had told the lawyer about this meeting, he held the lawyer in contempt on the spot and said that he was jailing him. He jailed him for several hours. This was Tuesday, I think, last week, saying that the lawyer could get out from under the contempt by answering the judge's question about who had told the lawyer that this had happened. So this is the idea of purging the contempt. So for contempt proceedings on the civil side, if you do something, you don't want to do something, and the judge says you have to do something, then a judge can hold you in contempt and you can purge it. The lawyers will say you have the keys to your own jail cell, that you can get out from the jail cell by doing whatever it is that the judge has told you to do. So the judge was trying to apply apply that in this situation, but he wasn't doing civil contempt, he was doing criminal contempt. And in criminal contempt, there is no purging. Criminal contempt is like any other criminal charge. You get a sentence for that. So this judge, on top of all this other stuff, has no idea how the contempt
But
procedures work.
Leslie, it's more than just a sentence. Criminal contempt is, the judge basically says, if you don't obey my order and do what I tell you to do, I'm sending you to the lockup, and
Right,
you will stay there until you comply. That's a civil contempt,
right,
and it all happens in front of the judge. You're not a convicted felon if that
right.
happens. You might remember the reporter in one of the Bush uh, uh, attempts to go after a reporter's sources.
Right. That's often where you see this kind of contempt
Yeah,
is for journalists.
and the lady journalist went to jail for a
Yeah,
month,
yeah.
and refused to give up her source. But criminal contempt is like any other criminal charge.
Right.
The defendant is entitled to be
Oh,
charged formally
you get a
in
hearing,
writing.
you get a
You
lawyer,
you get a
you get
lawyer,
notice.
you get a notice, you get a trial,
Judge didn't do
and
any of
and
that. He was just like,
and
boom.
and here's the key part of that. Usually, the judge is a witness in that case,
Right. Usually
so
another judge has to handle it.
another judge has to handle it, because the judge who has charged him with criminal contempt is going to have to testify about what the circumstances were, and
Right.
etc. So he's a witness. He can't
Yeah.
be the judge.
Now, he can in some. There's two kinds of criminal contempt. So, if you get a lawyer who says something rude, obnoxious to a judge can hold that person in kind of a summary contempt. You have offended the sensibilities of the court. Okay? That judge can deal with that on the spot. But this is not what was going on here. This lawyer he wasn't doing anything disrespectful to the court. He was not doing what the judge wanted, which was giving up information. And oh, by the way, that information was almost certainly protected by lawyer client confidentiality. So the lawyer couldn't give him the information even if he'd wanted to. So a judge cannot hold a lawyer in contempt for not giving information that the rules of professional conduct require him to keep secret. So this judge, he's just so far off the mark all across the board that it was insane. And I was watching this develop. One thing I thought was really funny, you guys, was that as this developed over the course of a couple of days, lawyers on the left and on the right, everyone was in agreement with this. Everyone was like, yeah, you can't, this judge can't do this. Like he's just messing up one thing after another. And what was even funnier, did you guys see this? A lot of the civil lawyers were like, wait a minute. The judge can't really do that to you, can he? And the criminal lawyers were like, no, of course not. That just can't happen. So the judge threw this lawyer in the lockup for a couple of hours, and this was pretty awesome. Two things happened. So the lawyer's wife is also a lawyer. She filed a notice on the points you're making, Ship. She was like, yeah, no can do, judge. You had to give him notice. You had to give him a hearing. You couldn't, you can't do it this way, dum dum. And we demand that, you do all the procedures and do it the right way. And then also Ashley Merchant. Do you guys remember her? She's the woman lawyer that did all that whole thing trying to throw Fannie Willis off of Trump's case. She's a fabulous lawyer.
Fonnie, what's wrong with you?
Yeah, whatever. So Ashley Merchant is a fantastic lawyer. I think she's the head of the Georgia Criminal Defense Attorneys Association. So she's the one that came up with that theory that Fannie and her boyfriend can't both be on this case, and probably neither one of them should be on Trump's case. Anyway, she showed up in this courthouse because this is where she practices, and she's now representing the lawyer, Steele, in the contempt proceeding. And I love this move. She brought 25 members of the Georgia bar with her to come into the courtroom, basically to sit there in the gallery and send the message to the judge that, these are the lawyers in this courthouse, judge, and you can't do this to one of us. This is not okay. But he wouldn't let them into the courtroom. What'd you guys think of this?
But she made it a point several times that
Yes.
they were out in the
hallway. Right.
My co-counsel, my 25 co-counsel.
Right. That's what she kept saying. Right. We're all here to represent him. And basically, you guys, what that means is she's telling him the legal community is telling you, judge, what you're doing is wrong and you need to stop. So, but he didn't let them in. Even some reporters on Twitter were like, there's plenty of room in the jury box for these lawyers to sit there. Like there's no jury at the moment. So, but this judge panicked. There were times where he said he would leave the bench for 5 minutes. He took a 5-minute recess to go and look at things, and then he'd be gone for an hour. So I don't know if he was trying to talk to other people in chambers to get guidance on this, or he was doing his own legal research, but he just kept screwing up one thing after another. And so eventually they did have a hearing later on in the day, and the judge was going back and forth, and he found the lawyer in contempt and sentenced him to 20 days to serve. But he said he could serve it on the weekends because they're still in the middle of this trial. And then the lawyer, in another boss move, was like, well, judge, can I have the same jail cell as my client so at least we can prepare?
Yeah, Leslie, before that, the lawyer had, when he was first held in contempt and ordered to report to the
lockup, yeah.
He was not he ordered the courtroom deputies,
the marshal or whatever,
take him into custody.
Yeah.
And they did right there in open court.
Yeah.
Whereupon he says, just a minute, I got one more thing to say. He walked up to the podium. He said, Judge, I moved for a mistrial.
Yeah.
Because my client has a right to counsel.
Right. And on top of everything else, you're depriving him of his right to counsel.
And you're removing his counsel and putting him in jail. So my client's entitled to a mistrial.
Mistrial, right. Oh, my God.
That's when the judge backed off of the immediate lockup.
Oh, my God. And if you saw the video, people, I think, didn't appreciate this. That lawyer, he took off his jacket, he took off his tie, he took off his belt, he either took his shoes off or took the laces out. He was just like, all right, let's go. Because when you go back to the lockup and you're a detainee, you can't, they take all that stuff away from these guys in state court, especially. So you can't injure other people and you can't, injure yourself and blah, blah, blah. It's a control device more than anything else. But anyway, just the sight of him ripping his jacket off, like, all right, up, lock me up, then let's do it. That made me laugh really hard. So I watched this and I thought, wow, this guy is really doing what, in law school, we all, are taught that this is how you defend people. You're not supposed to just let the judge run over your client and all of his rights, you know. So, but a lot of lawyers don't conduct themselves that way, but this guy did. So, my hat's off to him. And I've read different things saying that he's not like a fire breathing, different lawyers have different styles, right? This guy's not a bombastic flamethrower. He's just like a sort of, getting the job done kind of guy. But he was obviously outraged and offended that the judge thinks he can somehow have private communications with the prosecutor's office. So, in the middle of a witness's testimony. But what do you guys think about this statute? So, after I learned about that, I thought, okay, at least I can understand what the judge he's wrong, I think, but I can understand where he thinks he's coming from. But this is how far he took it. Even after that, all of this got straightened out and the witness got back up on the stand and testified. Then his lawyer that the judge had appointed, she tried to get unappointed. Like she didn't want to sit there through this guy's testimony. She wanted to be out of there. She asked to be removed from the case, and the judge was giving her a hard time about that. So she asked to come up to approach the bench and speak to the judge privately. And so she trooped up there, and the state did too. And then when the defense lawyers tried to go up, the judge told them again, I don't think you have a right to be here. He wouldn't let them participate in the bench conference. So, Ship, you were a prosecutor for a long time. What do you think?
Well, I mean, there are certainly proceedings where the government is excused from,
Right. That
doing,
happens more often, actually, you guys. Yeah.
and the defendant and the judge has to take up certain matters with the defendant. I just I can't even envision this ever happening in a federal court
Me neither. That would not
because
happen.
I made this comment online. This may be I think what you're asking me to comment about. You know, a witness going sideways is a variable in your case.
Right.
It's not up to the judge to try to salvage a deteriorating situation with a problematic witness. You shouldn't look to the judge for help.
Right.
And the judge should not be taking a witness into the chambers to explain certain things. I mean, a prosecutor in certain with certain narrow guardrails is allowed to advise the witness of the consequences of offering false testimony. I did it. I did it to a defendant once, which is really a dicey proposition. Told the defendant, if you testify and you lie, I will prosecute you for perjury. His lawyer went crazy. It was an exchange in an elevator, believe it or not.
Oh, ooh.
and 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 we had it. The lawyer raised an issue. We went back in before the court. The court said, you know, maybe it was inadvisable,
Mm.
but nothing Mr. Shipley said is contrary to the law. If your client testifies and he lies, Mr. Shipley can prosecute him for perjury.
There's some case law in the DC circuit. Pretty sure it's the DC circuit that, because I think this is where I researched it the last time, that says the judge should be doing that, right? Like if a witness has a Fifth Amendment issue, the court is supposed to advise the person that of the consequences and also of the consequences of perjury, because the cases are trying to prevent prosecutors from intimidating defense witnesses, because this is usually when this comes up.
Right.
Is you have a witness you want to put on and the prosecutors coerce
Right.
your witnesses off the stand.
And this was a situation though where it was the defendant and his lawyer was standing right next to him.
Right, exactly. So that's one thing. His lawyer's there. And you've got a witness, a defense witness. The government shouldn't lean on them to keep them off the stand. But this guy is a government witness.
And the government has, but he's become problematic.
Yeah,
And
right.
and the reality is they went behind closed doors, and the judge was trying to help the government keep the witness in line.
Right. Because we
And
all
so,
agree, right, that the government can talk to that witness all weekend, right? Now, there's the issue that he's already taken the stand, right? His testimony's already begun, but he's
right.
still their witness.
I had, I've had that rule sort of imposed a couple of different ways, and
Yeah.
I'm not completely on board with the idea that your own witness, that you, once they are sworn in and are testifying, that you can't have contact with that witness.
Right.
I've had judges tell me that, and I'm left scratching my head. It's like, well, he's already testified to what he's testified to, and what I want to talk to him about is testimony he hasn't given yet.
Right. And before he got up there, you could have talked to him all day.
Exactly. So I'm
Exactly.
not sure
Right.
why suddenly, because he's on the stand, he's off limits. Because
Well,
the defense would certainly ask on cross-examination, did you meet with
yeah.
Mr. Shipley over the
Right.
weekend?
Right.
What did you talk about?
Right.
It's all fair game.
Right. Exactly. The other side can question that. The theory of it is that the lawyer shouldn't be able to, outside the presence of the jury, fix things that the witness screwed up. Right. That you're depriving the other lawyer of being able to show that the witness, messed up in some way. But most of the time in the cases I had, the judges didn't impose that rule if the witness or the defendant, if it was over a long break, then they could talk to their own lawyers for sure, certainly the defendant. But a short break, they would tell them, you're still under oath. We're taking a 10-minute bathroom break. You can't huddle up with the prosecutor.
Right. And that's yeah. For a 15-minute break or even lunchtime,
Yeah.
that I disagree.
But
Or I agree.
when I had such a witness under cross examination and there was a break, and I smelled something, my first question after the break was, "Who did you talk to during the break?
Right.
And what did they tell you? And what did you tell them?" And I, you know, zero in on any shenanigans.
Monkey business there. Yeah. I know of a lawyer who did that in a deposition, and because they had gone for lunch in the middle of this deposition, and the lawyer had said to the client, "Now, we're not supposed to talk about the case over lunch, and we're not going to, right? So, let's talk about some other stuff because the other lawyer can ask you when we go back. Did you talk to me about your case? So we're not going to do that." So they talked about other stuff, and then when they went back in to the conference room for the second part of the deposition after lunch, the other lawyer said, "Did you go, did you guys go to lunch together with your lawyer, blah, 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 and did you talk to your lawyer during the break?" "Yes, we did." "Well, of course I did. I talked to my lawyer." "Well, what did you talk about?" And the witness was like, "Well, I'd really rather not say." And he's like, "Well, you have to say." And he said, "Well, what we talked about was what nice legs the court reporter has." So that didn't work out so well for that lawyer. But
Now I've had this issue come up, and I'll ask you what you guys think of this.
uh-huh.
The issue of, particularly in state court, the scope of an immunity deal.
Yeah.
Does it really protect the witness against the feds coming in and hanging him up based on what he says?
State immunity can't, right?
No,
Yeah,
absolutely.
right. And vice versa. I don't think, Ship, do you know that statute probably better than I do. The federal immunity, statutory immunity, doesn't protect against state prosecution either, does it?
Not that I'm aware of.
Yeah.
It's almost becomes just a comedy issue.
Right.
So I
I
have seen, I have seen witnesses and have had clients in this position where you have to advise them as to what risk you have if you
Right.
accept an immunity deal and still testify.
Right.
What are your what exposure do you have
You might still have
thereafter?
exposure
Yeah,
to the other
and
sovereign. Right.
then if and then the real rubber meets the road issue
hmm
is if the prosecution gives your client immunity and still takes the fifth
Right.
because it doesn't do away with all of his exposure, it's going to piss off some people.
Right. There's case law on that though, where it doesn't matter if the other um, sovereign is not involved in the case. If the person has a bona fide view that they could be prosecuted for a crime that they've committed, they can plead the fifth. It doesn't matter if it's the other sovereign. But in that situation, what the cases I've read say is basically you have to make a proffer, a pretty good one, to the court showing what, that the federal government, let's say, you're in a state court case and you're trying to say, well, the feds could still prosecute us. If you could make a bona fide showing that yes, that's a legitimate possibility, the judge should still let the person assert the fifth.
But this judge apparently, I think that was one of the issues here, and this judge wasn't hearing it.
Yeah. Well, I said publicly I thought this judge is dumb as a box of rocks, so there may be a reason why he wasn't, listening to any of that stuff. Because his order, the first thing he says in his order, where he officially held the lawyer in contempt, is that the lawyer was saying they had this ex parte meeting, and then in the second sentence he says there was this meeting, and he says who was there. So he's admitted in his own order that he had an ex parte meeting with the state. Now, he thinks he's allowed to do that because of that statute, but what do we think about this point of law? I don't think he's allowed to do that, notwithstanding that statute, in the middle of the trial.
But that's not the end of what he did. He yesterday he issued an order, a show cause order
Oh,
directed to
yes. Oh, yeah, we're gonna get there.
everybody who was
Yeah,
at the
at the
meeting,
meeting. Right.
including the court staff.
Right, I know, because this shows how dumb this judge is. I'm sorry to say that, but let answer my question first about do we think that he can even do this, and then yeah, we're going to go to those issues too. What do you guys think? Don't you think the Sixth Amendment right at trial trumps all of this nonsense, even if that case is correct that the defense can be excluded pretrial from an immunity decision?
I do. If the lawyer in good faith says I cannot tell you because of privilege,
Yeah.
and without a hearing, without any evidence, without any reasons, he says I don't care. Tell me. That's unlawful.
Right. No, but I mean, I don't think the judge can have that ex parte communication.
Oh,
He,
yes. I jumped ahead of you. Sorry.
yeah. Yeah.
Yeah. I think I agree. The judge has no business talking to a witness and the prosecution ex parte in the middle of a trial like that.
Right. Okay. So, Ship, are you in agreement with that? That Sixth Amendment trumps whatever this statute says or this Georgia case?
Yes.
Right. Okay. So then the judge as King is saying is like trying to figure out. He's doing his own investigation. So he's issued a show cause order to all the people that were at this meeting because he wants to haul them in front of himself to grill them, I guess, about who did they tell.
He wants to know the snitch. He wants to know who
Right.
the snitch was.
And okay, now you guys, how dumb must this judge be to not know that the defense lawyer got that information from his client who got it from the witness? Like, isn't it obvious that that's what happened?
It could have been the witness's lawyer,
Well,
or
maybe.
it could have been a court staff.
I think it's obvious it's the witness. They were locked up in the jail together over the weekend. Really? How? And then they had the meeting Monday morning? Right. I suppose it is possible that it's the witness's lawyer told the defense lawyer, but I think that it's very, very likely that it was the witness who told the client, and then the client tells his lawyer.
There are all kinds of possibilities. It could have been that the witness's lawyer told another lawyer on the defense team for some other
Yeah.
defendant,
Right.
who then passed it on to his client, who passed it on to the
This
the
guy's client,
this
right?
guy's
Steele's client,
client. Then
right?
he
Exactly.
finally,
Right.
it
But
could
how
be
how likely is it? Do we think that it's the court personnel that did that? That's absurd, don't you think?
no.
You don't think it's absurd that
No,
the judge's
absolutely
clerk
not.
or the
They
court?
got court people gossip. They gossip all
Well,
the time.
that's true. That's true.
Among the
But
court personnel that were there were security personnel too. So
right, of course. Yeah, there were like a lot of people in this secret meeting. But, I just that just strikes me as just craziness that the obvious route to me is through the witness and or the witness's lawyer. The state's not going to say. They're the ones that asked for the ex parte meeting in the first place, right?
yeah, based upon as I watched Steele try to introduce some of the comments, and the judge kept cutting him off, saying, "I want to know where
Mm.
you got this information," and he, Steele was saying, "Well, I'm not going to tell you that, but I want." Basically, he's trying to get the judge to confirm that the following things were said,
Right.
as reported to him. The few things that I heard him say, the level of specificity was such that I
Made you
would
think it was the
suspect
lawyer.
that it
Okay. Yeah.
traveled through the client. I would suspect it was the lawyer picked up the phone and said, "I think you need to know what's going on behind closed doors."
Right. That could be. But I
Yeah,
just think the first tip off that meeting happened
Could have been. Could,
is probably through the people, because in real life what happens, the judges are dumb, they're dense about this, and prosecutors often were too. All the people, the actual normal people in the case, the witnesses, the defendants, they all talk to each other. They don't follow the rules that the lawyers do about you can't talk to certain people. They don't care about any of that, especially if they're in jail together. They talk to each other.
But particularly with the bombshell that the witness dropped in the, supposedly, according to Steele, dropped on the judge and the prosecution in this secret meeting. I think he said he admitted to being the killer,
Yeah,
as opposed to Young Thug the rapper who's on
right,
trial.
right, exactly, right.
did you see any of his testimony? The clips from his testimony yesterday that were run
Yeah,
by
yeah, yeah. And the prosecutor, he's talking about how he lied to the cops, and this
every time.
oh
Every
my
time
god,
he said I didn't care what questions they asked me. I just told them what I thought would get me out of the room.
right. That's what people do, and cops and prosecutors have just no ability to accept that as reality. This has always amazed me.
And the prosecutor kept doubling down. You mean every interview? Yes,
Yeah,
every.
right, right. I just told you what you wanted to hear. Duh. How dumb are you? That's what happens. Yeah, and the prosecutor today, or was it yesterday, asked, "Well, why would you lie? Why would you lie to cops?" And the guy's like, "To get out, to get out of the jail. What are you talking about?" It's just the complete disconnect between the legal community and various elements of like society at large. Just
I
never
saw
ceases to amaze me.
I saw some commentary. Who knows who it's from, but like praising that prosecutor for her effort to deal with this difficult witness. And my
Mm.
reaction was, why put that witness on the stand?
Right. What you're
Your
not getting
case,
anything useful out of him at this point, for
your
sure.
case cannot rise and fall on this guy.
Right.
If
Yeah.
you know, a, a,
Doesn't
a,
it seem like they didn't realize this was going to blow up? Like it blew up on them. They just did not have the ability to foresee that this guy was going to be a problem. How could that be?
because they don't know what they're doing.
Yeah. Well, and they don't understand the relationships, which is almost always the case in this kind of case. So, but our friend Aaron, who's former federal officer, was like, these prosecutors basically just, lit their case on fire by having this ex parte meeting, right? A 6-month RICO case, and you just dumpster fire trashed it, in one morning. It's insane. All right. So, meanwhile, what this is something people thought was amazing. So the next morning, after the judge holds this lawyer in contempt and sentences him to 20 days, and then the next morning, everyone shows up for court. Like, okay, well, today we're back to whatever's next, whatever the next witness is, or this same witness, or whatever, right? And that's kind of how it is, especially in a long trial, right? You just move on. The next day, you start over again.
I
But
think that witness was on all day
yeah,
yesterday and most of the day today, and
yeah,
he hadn't finished yet.
no, no, he's hilarious in his own way. So, but meanwhile, uh, Lawyer Steele's lawyer, this merchant, and others on his behalf have filed for a bond and a stay in the courts, whatever the next court of appeals is there in Georgia, and have gotten it. So his sentence, his 20 days, which is totally illegal, has been stayed. So he will not be serving it. And what a mess! Wouldn't you hate to be the appellate court judge assigned to that and have to sort that sort that whole thing out?
The first issue they're going to have to decide is one, whether to appoint a separate judge to hear the contempt issue. And the second issue they're going to have to decide is whether this judge could be taken off the whole
Oh
case.
my God! Right, because like I said, I had a little more sympathy for him once I understood that there was this statutory proceeding and there is a case interpreting it saying that the defense doesn't have a role to play in that. But he seems to have missed the obvious point that all changes once you like swear the jury and start the trial. So, he's just not smart enough to grasp it, I guess. Oh, but how tyrannical he's being, like with this show cause, for all these people to show up and I guess out themselves as to whether or not they were the snitch. That's craziness. I didn't see King. When is that show cause hearing?
I do not know.
Yeah, I saw the orders, but I didn't have time to actually dig deep into it. So, mm, so all right. Well, we'll be following up with that. We'll look at that
Are,
again and
are we
talk
going to
about
talk
it.
about Fisher now?
Fisher didn't come out. Fisher didn't come out, and the immunity didn't come out. I thought that's what we were going to talk about tonight. And all we got was bump stocks. Not that I'm
Yeah,
not happy with that
actually,
case, but
there are four massive opinions,
massive cases,
massive opinions still to come out. One is uh, uh, the Chevron
right?
doctrine case, whether to uh, reverse that and change how they review uh, administrative
I predict
decisions.
I predict Gorsuch writes that opinion.
Okay.
I think you could be right about that. Could be Thomas, though. But anyway, the second is the Fisher case, which involves the obstruction charges they've been levying against the January 6th defendants and President Trump.
Right.
Uh,
Alito writes that opinion.
Okay.
the the third one is presidential immunity.
Roberts can write that one.
Robert's
Yeah,
definitely on
that's
that one, I
yeah, I
say.
think so too. Yeah.
And then the fourth one, that a major one, is the alleged coercion by the government of social media to
Right.
take people down and censor their speech.
Right, because somehow the Department of Justice thinks that the bully pulpit allows them to suppress other people's speech, which it doesn't, you guys.
Thomas writes that one.
Think so? Okay. All right. So there are a handful of others that are not as important. By last count,
I heard somebody say there's 20 cases left.
yeah, there are. There's like at least 15.
Next week's the last week, right?
Yeah, exactly. So, well, you know that this is the problem. See, is they have to decide stuff that they shouldn't have to decide. Back to my rant earlier, right? Because the system just doesn't work the way it's designed to work. It's absurd. So, all right. So we're not going to talk about Fisher because it didn't come out yet, but we might talk about that next week. So, but we did want to talk about Hunter's case. So everyone knows, I'm sure, Hunter got convicted of his 3 counts in Delaware on basically it's line, and line. It's a gun statute, but the whole thing is line. It's what it really is. And he's undoubtedly going to appeal, but he cannot do that until he gets sentenced first, as it's repeatedly explained to people. A judgment in the criminal case is what you appeal. A judgment in any case is what you appeal from, and you don't have a judgment in a criminal case until you've both been convicted and sentenced. And actually, it's not convicted; it's found guilty either by the judge or the jury. You're not convicted until the judgment, which happens when you're sentenced. So, in the normal procedure here in our courthouse, the sentencing date would have been set the same day that the jury returned the verdict. But this judge didn't do that. And I don't know if that's just her or if that's the procedure in Delaware. Do either of you guys know?
No,
No.
my experience is all basically it's 12 weeks. The judge will just pick, a day in the week, 12 weeks out.
Right. 3 or 4 months is usually how long it takes for the U.S. Probation Department to do all the stuff they need to do in order to give the judge the sentencing guidelines analysis. But I looked at the docket today. There's no sentencing date set yet. Now, in the meantime, Hunter's lawyer, Abby Lowell, filed 3 motions for judgment of acquittal. So these are motions. I didn't see on the docket that he re-raised them after the end of the evidence. Maybe the clerk didn't put that on the docket. He filed them while the jury was deliberating or while they were still working on the instructions and stuff. So you have a right to file that motion several times when you're the defense. You have a right to ask the judge to acquit you at the end of the government's case, again at the end of your case, again at the end of the evidence, and then again at once the jury has even rendered a verdict, you can ask the judge to set that verdict aside. So it's very close to the same legal test for all at each one of those points. But at each one of those points, obviously, the judge is looking at a different amount of evidence. So what happens is In practical reality, most of the time the judges don't rule unless they're going to give it to you, unless they're going to find you not guilty. They don't rule on your motion at the end of the government's case. They hold it in abeyance. You still file it, and the judge will rule on it later, and the judge will look at that motion as if the rest of the case hadn't happened. That's the theory of it. Now, in practical reality, that doesn't happen. What happens is you make the motion at each point that you are entitled to, and then if the judge is actually going to say the jury finds you guilty, if the judge is actually going to reverse that, they usually do it, technically they do it on the motion that you filed for judgment notwithstanding the verdict, and they evaluate all of the evidence. I wish they wouldn't do that in some cases, because like I've had cases where we had a very good argument that the government just didn't make their case, right? The case should have been thrown out with that amount of evidence, and there are consequences to that under the federal rules at what point the case gets thrown out. But the judges don't want to deal with those nuances. They just want to, wait to see what the jury's going to do. So Abbe Lowell made these three different arguments. And like I said, I can't tell from the docket whether or not he re-raised them. I assume he did, because he should have, at the end of the whole case. And then he has a right to file more motions, now that the jury has convicted of making the same arguments. The government today filed a memorandum in response to one of them. King, did you see that? I know you had looked at Abby's motions.
I did not.
Okay. So it looks to me like they've only responded to one of them, and that's on the insufficiency. King, do you want to discuss those motions, or?
I remember I wasn't impressed.
Yeah. So one of them is that there was just insufficient evidence to convict him of the crimes that were charged. That you make that argument pretty much in every case, right? The government didn't meet its burden of proof. That argument didn't look too good to me. Second one was he filed a motion, what he called for count 3, for charging a non-crime. So count 3 is the statute that says you can't possess a gun if you're an addict or you're addicted to X, Y, and Z. And so Abby's argument there is that, well, this was the argument we were discussing. You guys remember, like the statute got redrafted and moved around. So Abby's really arguing that the statutory language got repealed and no longer exists. But Ship, I think you didn't agree with that, right?
I don't. My view is the way the statute was amended was all they did was change the penalty.
Right.
And they did it by moving sections around. So they took it out of the lower penalty and they moved it into a subsection that had a higher penalty. But there was no obvious intent to
take some things out that previously were
to,
crimes.
to change the law in any other way. So Abby's argument is, well, when you took it out of the first section, that means that when you can't be charged for violation of that subsection because it's not there anymore.
Right.
They've moved it into a higher penalty section. And if you did it there, it would be ex post facto.
Right. And see, that argument might have legs because the penalty changed, right? But I don't know.
Yeah, they didn't charge him with the higher penalty. They didn't charge him with the new subsection. They charged him with the old one,
right?
Which was in effect at the time of the crime,
right?
And it's a super technical argument,
right?
That if you put your practical hat on, doesn't really fly.
Right. It's an interesting theoretical argument. Is this a change that the Constitution would prohibit? So when lawyers say ex post facto, means after the fact. So the ex post facto clause in the Constitution says you cannot be punished, prosecuted or punished, for things that were not illegal at the time that you did whatever the conduct was. That's the simplest way to understand it. But the application of it can be technical.
It goes beyond that. You can't charge somebody. You can't change the penalty for a crime.
Right, exactly.
After you've done it.
Well, you can, but then the person can't be sentenced to the
The
higher
higher
penalty.
penalty.
Right.
Right. That's
Because
acceptable.
ex post facto also, right? Because, the legislatures change stuff all the time. So the judge has to figure out, well, what was the law that was in effect at the time that you committed the offense for purposes of sentencing? And so Abby's argument basically is, well, they moved this around into the higher section and it's not in the lesser section, so that means they can't impose the lesser section. Oh, okay. That's a hyper technical application of it, which probably is not right. But, it's I don't know of any case directly on point that says he's wrong either. So that's interesting, but I don't expect him to win on that. His best argument was the third argument. He asked for judgment of acquittal under the second argument as applied and the Fifth Amendment. As the Second Amendment as applied and the Fifth Amendment. And here he's really arguing that you have a Second Amendment right to possess a gun, and the government can't infringe on that by saying, well, you can't own a gun because you're an addict. And even if that's unconstitutional, we still get to ask you if you're an addict. And if you lie on that question, which we shouldn't be asking you in the first place, that you can't have the gun because you made a false statement. That's basically his argument. So,
And there is law to support part of that argument. That
right.
is, the Fifth Circuit has held that uh, a law that prohibits an addict from owning a gun is unconstitutional violation of Second Amendment.
Right, I agree with that. I think that's correct, a correct interpretation of the Constitution. So, but then the more thorny question is, does that mean that the statute that criminalizes lying on the form is also unconstitutional because they couldn't ask you this question because asking it infringes on your right to possess? Does that mean you can lie, though? Right? And there's just two ways to look at that. One is, well, you can lie to anything. This is my view. You can lie to the government for things that they shouldn't be asking you in the first damn place, right? That's not really a lie to them. But that's not always the view that carries the day. So, Ship, have you got any views on this?
Hang
Ship,
on.
do we lose you?
Oh,
Yeah.
yeah, no, I'm sorry. Yeah. I mean, I sort of a little simpler approach to that. We talked about this the other night. Is, you know, I think that the court eventually is going to. I mean, this may end up getting tossed out in the Third Circuit there in
Yes.
Delaware, Philadelphia. Um, this I think there are several cases teed up around the country on the G3 922 G3, which is the addict in possession provision. Fifth Circuit has already said that's under the Bruin clarification, where the Supreme Court went in Bruin, um, that there are limitations on Congress's ability to restrict firearm ownership to the kinds of limitations that were, I can't remember exactly, customary at the
Yeah.
time the Second Amendment was passed.
Right.
Um,
They
that
weren't. They were not precluding drunks from owning guns then. So,
correct,
yeah.
and and that generally the prohibitions that existed, as I heard discussed on a podcast, they only existed as long as you were in the condition of drunkenness. So you might have been dispossessed of your weapon while you were drunk, but when you were sobered up, it was given back to you.
They give it back to you, right?
Uh,
And the kind of things that were done then were like if you were what in the old days people would call crazy, right? Mentally incompetent, we would say, or for felons, people who had a sufficient criminal record that this was problematic.
right.
And
So
we still do those today. I don't think those are unconstitutional, but this I think is unconstitutional. So go
right.
ahead.
So it's very likely that all the circuits will eventually line up. I don't know that the Supreme Court will actually have to weigh in and tell them, look, the writing's been on the wall now. And the Third Circuit will be one of those. Whether or not Hunter's case gets, I mean, I think in the Third Circuit, it's still good law. So the district judge is going to have to deny that motion just on the basis that she is bound by the law of the Third Circuit
Right.
until the Third Circuit changes something, or the Supreme Court, takes up the case out of the Fifth Circuit, which they won't until there's a split. Um, so, which kind of raises an interesting question: is does Hunter end up going to jail while this case is being? Although he'll certainly appeal it. He'll certainly appeal it to the Third Circuit, and I think the judge would give him bail pending appeal because it is a
Yeah.
substantial question.
Right. That could
but
reverse, and then he shouldn't be serving. Right.
yeah, and then you the next step is what you've raised. The issue, the way I approached it is the lying on the form. Well, lying on the form is immaterial if it was not actually a crime.
Right.
If those questions weren't relevant to any law enforcement purpose because the law to which it might apply was always unconstitutional, then they would not be materialized to the government, would not be prosecutable. So therefore, those two counts would get stricken as well. But I don't think, I would have to look at it. I haven't done that guideline in a long time, but I don't think that guideline, absent an aggravating fact, I don't think the mere possession is much of a sentence. I think it's
Well, I was looking at that today because I wanted to talk about that. So let me pull that up. So this guideline, he's talking about the sentencing guidelines, you guys. So as you all know, you get convicted of whatever you get convicted of. And then in the federal system, they apply the federal sentencing guidelines. And there's an index, a table in the guidelines themselves that say, if you get convicted of this statute, this is the guideline that you apply. And if you get convicted of this statute, then this is the guideline that you apply. And this index is I don't even know how many pages long, a dozen, right? Because it lists, is the index more than that? Okay. It lists almost every crime in the federal code, but not every crime. So, but it's pretty close to all of them. And so what you do when you're a practitioner is when your guy gets convicted of whatever statute, 1922, whatever it is, then this is 922. I'm just making this up.
G3.
Yeah. You go to the index and you say, if you don't already know, and you say, all right, this is what my guy got convicted of. Which guideline do I use? So the guideline for these gun charges is K. K is in Kalamazoo. And so it's 2K 2.1 is technically the guideline. And this thing so under the guidelines, you start out with a base offense level that this is how many levels it's worth, the case. And then you can add on to that level with things called specific offense characteristics and other things. And you can take levels off with other factors.
I'm going to guess that the base offense level here is 7.
No. And you can also take levels off by pleading guilty. But if you go to trial, obviously you don't get those levels off. Now, Hunter went to trial, so he's not getting levels off for that. This guideline I don't know if it's unique, but it's unusual. So it has 1, 2, 3, 4, 5, 6, 7, 8 different potential base offense levels. So this is very unusual. Usually, like if you have a fraud case, the base offense level is, what is it, Ship? It's 6, right? For 2B1. And so, it's not like you normally have this many options, but this section does. So the first base offense level is 26. That is serious heavy duty, people. That's for an offense involving a semi-automatic firearm that's capable of accepting a large capacity magazine, or the firearm is described in certain other sections, and the defendant committed any part of the offense subsequent to sustaining at least 2 felony convictions of either a crime of violence or controlled substance offense. So to start out on level 26 is pretty crazy.
Well, that's career criminal, basically.
Yeah, exactly.
2 priors.
Right, exactly. So level 26, where's my table at? Level 26, even if you have no prior criminal history, which you wouldn't, because to get this guideline, you got to have 2 prior felonies.
You're 57 to 71, or about that?
Level 26, let's say category 2, is 70 to 87 months. That's to start with. Okay. Now, Hunter doesn't have those priors, right? So that one's not going to apply to him. The next one is 24 if a bunch of other stuff happened. Again, more felonies. The next one is 22 if it involved a semi-automatic firearm, again, large capacity magazine, and the defendant committed any part of it with 1 felony conviction. Okay, so then the next option is 20 if a bunch of other stuff happened. 18 if the offense involved a firearm described in another section. Okay, finally we're getting down to where maybe we're going to get to Hunter. 14 levels if the person was a prohibited person at the time the defendant committed the offense, is convicted under 922D, 932, or 933, or, not and, but or, is convicted under 922A6 or 924A1A, and committed the offense with knowledge, intent, or reason to believe the offense would result in a transfer of a firearm or ammunition to a prohibited person. So Hunter has convictions now under 922A6 or 924A1A, but didn't seem to me they had any evidence that he was going to transfer that firearm to someone else who was prohibited, right?
What are those two? Are those the two lying on the form?
Yes, they
Okay,
are.
then that's a straw buy. That's the straw buyer.
Yeah, it's a straw buyer provision. So, but the first part says if the defendant was a prohibited person, and because they convicted him of that drug, being a drug addict in
Right.
possession, that I think is going to qualify. The definition of prohibited person says it's that list of prohibited people over in 924.
But there has to be a second provision that applies. What would be the second provision that applies?
What do you mean second provision?
Well, I don't think it's 14 just for being a prohibited person.
It says 14 this is for the line on the forms. 14, if the defendant was a prohibited person at the time the defendant committed the instant offense, at the time you committed the line. It doesn't say you have to have been convicted of being a prohibited person. It says you have to have been a prohibited person.
Okay.
So, yeah.
What's the rest of
It's the other alternatives that don't apply to him. So it's 14 if he satisfies that he was a prohibited person at the time that he committed the line on the forms offense. That's probably going to be the government's position, is that the base offense level is 14. So if they can talk the judge out of that and say, well, he had to have been designated as a prohibited person right
So what's
beforehand.
That, 24 to 30 months?
14 is, go back to my tables. Where did it go? I lost it. Hold on a second. Where did my table go? It's no good. Oh no, maybe I closed out of it. Hold on a second. Here we go. Okay, 14 for category 1, because as far as I can tell, Hunter Biden has no prior criminal history. Level 14 is 15 to 21 months. Okay, so I think that's the highest it's going to start at for him, is there. And then they're going to try to add stuff maybe. But he might have the argument that instead of 14, it should be 12. Because...
What's zone B, 11?
Yeah, 11 is the top of zone B. So, yeah. So what Ship is saying, you guys, is on the sentencing table, there's levels and there's zones. And so the first 8 levels are in zone A, 9, 10, and 11 are in zone B, 12 and 13 are in zone C, and 14 and above are in zone D. This is if you have basically no criminal history.
And the importance of that is if you're in zone B, then even if it calls for a sentence of imprisonment, the judge has the discretion to sentence you to probation so long as the lower end of the imprisonment is served either in home confinement, intermittent detention, or community confinement.
Right.
So
it's like halfway house, home confinement type situation.
Yeah. So
but to get there, you have to be on level 9, 10, or 11. So it's going to make a big difference whether he starts out at 14 or whether he starts out at 12. So this definition under the statute of being a prohibited person, in a normal case, I would wonder if this was why the government went after that, is to try to get this, additional little bump on the sentencing calculation.
At the end of the day, though, she can vary downward to.
Yeah, she could. Yeah.
So,
but this is why, you guys, I've seen some public reporting on it. Lawyers are saying it's very hard to tell what his sentence is going to be, and it's because this guideline is very complicated, and it depends on a bunch of factors that are going to have determinations that are going to have to be made by the court. So it's a little less easy to see exactly how it's going to play out than it sometimes is in federal cases, where the guideline is a little easier to apply. So, but um, so Ship, in terms of the sentence, though, I mean, she could give him jail, right, to serve. Actually,
Well, she could, but
yeah,
he has no prior criminal offense. He's clearly
right,
had a raging drug habit that he
right,
might have under control now. He's been subject to testing for how long? He's probably been required to attend, drug, counseling sessions. And I
right.
think it's one of those circumstances where so long as everything is, as long as he's maintaining that path, the complications of giving him a prison sentence are dramatically outweighed by simply giving him home confinement.
You mean because of who he is?
Yeah.
Yeah, right. So now let's say he was. I mean, if his name hadn't been Hunter Biden, I really question whether this case would have been brought at all. But it could have been because he did get swept up, right? His name initially surfaced because of that underlying investigation. So,
I had a client get 50. I did
yeah.
not represent him at the time. It was a prior offense when I was still actually a prosecutor. Got charged with the same offense. Got 15 months. Now he had some cross pollination with some drug trafficking that he
Mm,
wasn't charged with.
right,
But on this exact charge, he got 15 months.
right.
So it
So,
does get charged. People do go to prison.
right,
The talking heads out there saying that's not true are talking out their ass. I
right.
know it's true.
Right. It does happen. It just doesn't usually happen, is the answer, I think.
Well,
But,
generally, if you've got somebody who's an addict in possession, you have other issues. So you might have a
right,
felon in possession. You might have other ways to charge it.
right,
But where this is, it is commonly used as the disposition charge simply because the person might be cooperating, but they're going to eat some charge. So
you're talking about lying on the form, not about being an addict in
no, I'm
possession?
talking about being an addict in
Really?
possession.
Okay.
Yeah, G3 count.
Yeah. See, I'd never seen one of those. So it may be that they just don't charge them as much here as they do other places too.
And that is very true because
Yeah.
remember, a lot of people don't realize this. Individual U.S. attorneys have their own district priorities.
Right.
Some are more aggressive in charging gun crimes than others.
Right.
Some have bigger gun crime problems than others. I'm going to guess
Right.
that Delaware probably doesn't have a huge gun crime problem.
Right. Well, and
Could
if
be
you're doing
wrong.
it as a plea to resolve things overall, then that defendant is not going to make the arguments that Abby Lowell's making here that this stuff is unconstitutional.
Right.
Right. So it's not good because there is a problem for the government potentially that these statutes are unconstitutional. And do they really want to have the courts decide that? They have not really wanted
Yeah,
to.
absolutely. But that wasn't true 10 years ago, 15 years ago, 20 years ago when these charges were very commonly used. Now,
Right. Or when they were drafted. Right.
are they
Yeah.
used post Heller to the degree that they were used before? Probably not.
Right.
Are
Exactly.
they used post Bruin to the degree they were used before? I'm certain they're not because
Right.
I think the writing's on the wall. People know what the outcomes are.
Right. So you got to wonder why would you even in this guy's case, they didn't need to bring this addict charge. They could have just brought the line. Of course, it runs you into the possession. It runs you into the same problem that might be all of it unconstitutional. So,
Well, and I think that was an issue of they were unwilling to exercise prosecutorial discretion in that fashion because he was Hunter Biden.
right.
It's like,
Well, and there's a bunch of other nasty shit that they, let the statute run out on and
Yeah.
various other things.
and
Yeah,
it's still a good charge in the Third Circuit.
yeah,
Yeah.
and that's a complicated issue that leads me to my takeaway from this case.
Yeah.
Number one, above all, is the laptop is real.
Correct. That is not Russian disinformation. Barb
That's
McQuaid
right.
does not know what she's talking about, so
Yeah,
don't listen to her.
and number two, the only reason this thing is being tried is I'll just put it bluntly, uh, unbelievable arrogance by the defense
Ineptitude.
counsel.
Yeah, right. That's like that quote in Mad Men when Don Draper tells the client, well, that was just ineptitude with insufficient cover. That's exactly what happened in that plea hearing. Oh, go
They
ahead.
thought they could get it all.
Yeah.
And they had it all, but the judge called it out, and they didn't have a backup. They had no backup plan, so they said, "quote tear it up,"
Right.
which happened, which was the worst thing could have happened to Hunter.
Right. Exactly. Right. His own lawyers screwed him over that day because they were incompetent.
Yeah,
Well,
and once they had gone down the path of saying we're going to pursue this charge, but we're going to take this exit ramp, which gets him out from underneath everybody else, there was no longer a reverse gear to say we don't want to pursue this charge.
these charges, because these charges are dumb if we have to try them. Right. Yeah. So you guys may have noticed that none of the motions for judgment of acquittal were based on the argument that the diversion agreement and the deferred prosecution and all of that are in force. And that's because Abby Lowell raised that pre-trial. He raised that as a motion. The judge denied that motion. So he's preserved that for appeal already. And the motions to acquit motion arguments are usually having to do with the evidence wasn't good or that the law that you're being prosecuted under is legally invalid in some way. So he still has that argument. He just didn't raise it in the motions because that was already preserved for appeal. But I expect him to raise that on appeal. Um, and so we'll see. His best arguments in this case were all legal, don't you guys think?
Oh yeah, he lost his case like first day when the when everything Abby Lowell, all the defenses Abby Lowell gave the jury just got blown out the water
Right.
immediately.
Yeah, that was some not great lawyering, I thought. You can't put stuff out there like that that the government can immediately undercut. That is not good lawyering. But at the same time, he doesn't have any factual defenses that I could see beyond jury nullification. He doesn't have any factual defenses to the charges, assuming the charges are good. And once you ask the judge to say the charges are not good and that motion gets denied, you still have to try the case, right? You just got to wait to get to the Court of Appeals. So this kind of a trial can look like a slow plea from the defense point of view because you know you're going to lose on the facts.
Uh, which raises an interesting question because Abby is held in the highest regard in the defense bar. He is a damn good
Yeah,
lawyer,
he is a good lawyer. Yeah,
and the lawyers that Hunter had before him uh, weren't from Delaware, but they didn't have bad reputations.
right.
They were not flea bag lawyers off the
They were
street corner.
expensive lawyers. Yeah,
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 they were white shoe lawyers. They
right.
knew what they were doing, but there was a common element to both defenses, which was arrogance. I'm
Right.
a damn. I'm representing a Biden, and you can't do that.
Can't do this stuff to us. Right.
Just to and
Right.
both defenses, both set of lawyers' defenses, kind of rode that horse. So, which leads me to wonder: was it the lawyers screwing up, or was this a Biden issue? The client, was this directed by the client?
I would say for the plea, no. I put that squarely on the lawyers. If they had negotiated that deal and then they'd gotten a local lawyer who is a regular in that courthouse who knew that judge, that thing would have gotten papered properly. Hunter would have gotten prepared properly, and that plea would have gone through. And his case would have been over. But instead, they had these lawyers who kind of weren't from there, right? Or they weren't regulars in that courthouse, and that hurt them. And the paperwork was, very unusual. That hurt them. What they should have had was somebody, an old hand in that courthouse, who's going to do it the usual way. The judge gets what she's expecting to see. That would have been the end of it. But on the other stuff, I do wonder if you're right, King, because like one of the jurors told Fox News after the verdict that they didn't like it that Abby called Hunter's daughter as their only witness. They didn't like that. That looked like a misstep, a wrong move to me that I was surprised Abby made that move. But maybe sometimes you do call a witness because the client really, really wants you to.
But
I mean, this defense was all about just playing for one vote.
playing for one vote,
playing for one
nullification.
vote. So
Yeah,
maybe it does irritate. Maybe it did backfire on 11, and they might have
yeah,
understood that that was going to happen, but they probably lost those 11 anyway.
yeah. I always used to tell clients, sometimes you hear lawyers say, well, you only need one. I always used to tell them, no, you need two. You need one person to be convinced that they shouldn't find you guilty, and you need a second person to hold that person's hand. But yeah, you're right. They kind of, nullification really was their main argument, at least at trial, right?
It was, which is a really, really roll of the dice. But back to the plea deal
Hmm.
that was blown up, even after they screwed up, didn't do their paperwork right, got caught out by the judge. Even then, you had a willing prosecutor and a wink and a nod deal
Right.
that all Hunter and his lawyers had to do was to say, okay, we'll go with the deferred
Right,
prosecution
exactly.
on the,
Right.
and just cross our fingers on
Right.
everything else.
Hold our nose and
Yeah,
say yes, and then it's all over with.
it's
Right.
over.
Yeah. Right. And
That
that's what I'm saying. They didn't properly prepare Hunter.
that doesn't take a genius.
No, it doesn't. That's what I'm saying. They just needed a guy who's, in that courthouse every day. But that's not what happened. That lawyer whose name I can't remember, he's the one, the defense lawyer, he's the one that blew it up because he wanted to say that the non-prosecution part of it covered more, whatever. They had a divergence of agreement on that. You don't worry about that when you're trying to get the plea put to bed with the judge. But he blew it up. So now his client stands convicted of 3 felonies and is looking at, problematic sentencing considerations. So that's where we are. So I don't know. I don't know very much about this judge to know like what kind of a sentencer she is. Have you either of you heard anything about that?
No, I have no information at all.
Yeah,
Uh,
new judges tend to be lighter. They get more heavy-handed as they go. King, what were you going to say?
I have no idea.
Yeah. So, you know, she's going to have a lot of options, but I'll be interested to see what the argument is about whether or not the starting level is 14 or 12, because that could make a difference with how comfortable she is then getting into zone B that the ship is talking about. Because 14 is in zone D is in dog, 12 is in C. So it's not as far for her to say, well, I want to do something a little better than that to go from C to B than it is to go from D to B. So yeah, so we'll keep an eye on that. But right now, she's just letting them do the post verdict, legal arguments, and then she's going to worry about the sentencing later.
Speaking of which, I think the consensus in the legal community is the tax case in California is not going to trial.
Okay, tell us about that.
Will not be because uh, one, I question whether Hunter can afford it. Question
Hmm,
whether his daddy politically can
right.
afford to risk it, and uh, that's a tough one to win.
Oh, you mean that it's going to be a plea as opposed to the
It's going
government's
to be
going
a
to drop it?
plea. Yes, yes.
Okay, yeah,
I, that would surprise me because his downside consequences in that case, in terms of a prison term, are much greater. Although you could be right in the sense that his by accepting responsibility, he brings that exposure down. But the tax loss there is pretty significant when it
yeah,
comes
and the
to
numbers drive up
the
the
guidelines.
guidelines. Yeah, yeah.
Yeah, I think it was the unreported income of 4 million and a tax loss of 1.3 million. It's
But
not
he's got a
huge.
father in the Oval Office. Don't ever forget that.
Well,
Absolutely. And actually, I kind of have only half jokingly said online that Joe Biden is more likely to commute his sentence than pardon him because Joe Biden's happy to have a felon not own a firearm.
good grief. Well, I did notice that the reporters asked the current president, would he commute the sentence, and the White House didn't want to answer that question.
Yeah, I think they're going to commute the sentence. They won't let him do jail jail.
Right. Yeah.
But they might leave the felony in place.
Yeah, possibly.
He certainly earned it.
Well, on these felonies, I'll be interested to see if the courts will leave them in place. But if you plead to the tax, then you're stuck with that. So yeah. All right. Well, hopefully next week you guys will have some exciting Supreme Court news to talk about. Where are we on the round robin of the former president's legal trials? Ship, what's the schedule looking like?
Well, I will continue to maintain that neither federal case gets to trial, and now certainly the
Right.
Georgia case isn't going to trial.
Yeah. No
So,
time soon.
I had said none of them would get to trial, but that was sort of conditioned on the fact that New York was supposed to go last because it was such a
Right.
bad case.
Right. Exactly. They were going to go last after all of that other nonsense, and then that didn't happen. So, right. Um, well, we had said that, if the Supremes didn't decide this immunity issue until the end of June, that that was really going to put a time crunch on Judge Chutkan to try to get her case, for her to try to get it to trial before the election. Now, we all, I think, still think that he's just going to appeal that again, whatever her rulings are on how to apply.
Well, let me ask you. Okay, so maybe you know you or maybe if we get Steve to weigh in here. How does the timing work? Let's say next week the Supreme Court reverses, but they're reversing the appellate court. So it has to go back to the appellate court. Then the appellate court has to instruct or reverse back to the. I mean, it doesn't just jump right back to the district court, right? In other
No,
words,
I think you're right. They reverse the circuit. The circuit then has to issue a new mandate down to the district court, is the way I think that it works.
right. So I just
Saying
don't
what
know
the
what
answer is.
the
Right.
mechanics of that in terms of the days that would be lost while that, although it's just hit the enter button on a computer,
Right.
but
It's not going to be very many, so probably not enough to make a difference. But so let's say 4th of July comes and goes, and Chotkin has the case back, right?
right. And she's already said there's 88 days to be added for pre-trial work. So
Well,
that's roughly 3 months.
I
So you
haven't
have
checked Ship. I didn't check that, but somebody did today, and assuming they can count, if it goes back, if the decision comes out next week on Thursday, the 20th, that time that Judge Chuckin promised the Trump team they would have to get ready for trial would take you to picking the jury beginning September 16th.
Yeah, but they're probably not factoring in this little bit of time the ship is talking about, which is it has to move back from the Supreme Court back
That
down to
okay?
Judge Chutkin.
Okay, add a
Yeah,
couple of days.
yeah.
Add a couple of
Well,
days.
add a week for that. So that's
but that's not right because I have checked the number. She said it will be 88 days.
88 days.
And 88 days is only 2 days less than 3 months, and 3 months from the first week of July is the first week of October.
Right.
Yeah, but I'm counting. I think this person counted from June 20, so, which is like the third week of
That
September.
that would make sense. Then you would be talking about mid-September, right? But
Yeah.
I think we're easily talking about the first week of July by the time
But
it
but
lands
but
back in her desk.
but that assumes no evidentiary hearing in
Exactly.
the district court to determine how much of the charged conduct was involved official acts.
Well, and also you have to. It also requires not considering not just the immunity question, but the outcome of Fisher. Because if Fisher guts the
Right.
215-12 counts, now he's got the defraud the United States count and the Civil Rights Voting Rights
Right.
Act case
Right.
or count, and that's you know seems to be the assumption that he could shove all the same evidence into defraud the United States count 371 or whatever that is 372. I can't remember. I'm not so sure that's accurate. I think there'd be
Right.
plenty of attacks to be launched on that effort.
Right. I'd file a bill of particulars at a minimum if I were his lawyers to try to pin them down on, well, what exactly out of this mess that you filed are you going to use for those 2 counts?
Right.
So, but let me ask you guys this. The 88 days that Judge Chutkan gave them, that seemed to me to be premised on the assumption that whenever the case came back from the courts of appeals, that the rulings were going to be whatever they were going to be, and then they were going to pick up with the pretrial proceedings and proceed forward to the trial.
Right.
Okay.
It's much simpler than that. It's from December 7th, when she lost jurisdiction, to March 4th, which was the day set for trial.
Right. I understand. But what I'm saying is, it seemed to me they weren't taking into account that maybe what they were going to get back is the obligation to hold another hearing, right? She's going to still hold that hearing on whatever the immunity application is. She's not going to wait the 88 days to do that, right? She's going to do that during the 88 days. Do we
I
agree?
think she'll do it in 7 days.
Right. She'll try to do it immediately. I agree. Yeah.
I think she
And
will
then he'll appeal again.
I think she would take the position that you've all known this was the issue. You all
Right.
should have been prepared for this to be the court's response. So we shouldn't need much time to gin this hearing up.
Right. And make some rulings on it, right? And
Right.
then, but he's just going to appeal that again.
Right.
So, yeah.
Yeah. So I think
Okay.
that's the fly in the ointment, is that he
Yeah,
will have
that.
the right to
But
appeal that again.
I think the biggest fly is a potential that the Supreme Court will mandate some sort of evidentiary hearing on how much of this was official acts,
Official, right.
and that's not a quick evidentiary hearing. That's complicated. That involves taking the entire case and looking at each allegation and each witness, and it could go on weeks.
Well, I
It
think the
won't
first
in
thing,
front of her, though.
I think the first thing Smith would do is take a scalpel or an axe to his 54-page indictment.
Right. Right. That's what I was saying. You got to have, somebody has to explain, especially if Fisher also throws those counts out, which is a good point. An excellent point, Chip. What is the fact pattern that we're dealing with here? It's not what's in this indictment. It's something less than that, but what part of it is in and what part's out?
I wouldn't be surprised if they already have another indictment teed up and ready to go.
I wouldn't
And,
either, actually,
and
an amended.
much,
Yeah.
And they just haven't tipped their hand, but it's going to be, radically trimmed down, maybe to just the voting, maybe to just the count on defrauding the United States, in 6 pages.
Right. That would make everybody's life simpler in one way, and King is right, not necessarily in others, because she's going to have to take evidence on the scope of the president's duties, unless she's going to do the thing, Ship, that you've always complained about, which is just base it on what's alleged. But I don't think that's right.
Yeah, that's the other thing. That's the first thing I'm going to look for in the opinion is, do they deal with the standard of review?
Right. Yeah. Well, there's 150 days to the election as of today. So let's assume Judge Chutkan is going to be fooling around for a while with this issue we've been talking about, this evidentiary hearing. And Judge Cannon has no trial date yet in Florida. Am I right?
And that case is so much more screwed up than anybody ever imagined.
Yes.
Now that these motions that were actually filed 3 and 4 months ago are public. Now you know why she vacated all those dates.
Right.
Because she could look at this stuff and say, I don't know, that should have been, if you haven't read, we should put this one on the calendar.
Okay.
There's now a motion to dismiss for spoliation of evidence.
Right.
And there is an unbelievable nightmare scenario about how the seizing agents and the filter team screwed up that search.
Right.
It is unbelievable. I started reading it last night, and it's like, holy shit, this has all been under seal.
Right. Yeah. So there's a serious problem there, and all of these folks who are like, oh, she's just terrible judge, and she's incompetent because she's just delaying it. You just don't understand how complicated some of those issues can be, and spoliation is a problem for the government when the defense has something to say. So my question there is that case isn't going anywhere fast, right?
No,
Yeah.
not a prayer in the world of that case going to trial, before the middle of 2025.
Right. So at least she's not blocking Judge Chutkin, right, from Judge Chutkin's point of view.
Right. And I don't think she's there. And that's kind of, I had, speculated a few times that maybe she would start to eat up calendar dates to do that.
Right.
Since, Chutkin had stuck her case in ahead in an effort to try to get it tried. But I think the reality is she just was looking at what was being filed and looking at the evidence that the defense is able to marshal about how the search was screwed up, the internal communications about how the filter team basically, the filter team basically said, we can't do this the way we were instructed to do it, so we're just going to do it the way we think we can do it.
We're going to do something else.
Which was contrary to the instructions.
Okay.
And then raised all the problems about not being able to adequately document where certain materials were. And it doesn't have to do with just classified materials. It has to do with the commingling of classified and privileged materials.
Right.
That the case team wasn't authorized to see, the privileged stuff.
Right. Right. So people know the filter team in general, people may think that has to do with the classified, but there's every case I handled the last 8 years at least, probably more than that, there was a filter issue because since the government seizes everyone's computers now, right, and all their emails and all of this stuff, they're always in possession of attorney-client communications. Not always, but in white-collar cases, it's always. And so, you would get communications about the filter team. You would get separate disks from them at a certain point in the case in discovery that of stuff that the filter team, brought forward because we've set up these rules that say supposedly the team of lawyers and agents that are trying the case are not exposed to the attorney-client communications. And so this is what SHIP is talking about. The way the searches are conducted, the Department of Justice has to build in this filter team process in order to try to grapple with the fact that their wholesale scooping up of electronic data, puts them in contact with defense communications. So that doesn't have anything to do with the classified. And it's very easy for them to screw it up in a complex case like this. And then when you layer the classified issues on top of that, I'm not surprised at all.
Well, just as an example, and got to keep in mind that Trump had been dealing with lawyers and these documents for months.
Right. And multiple sets of lawyers.
Right. So there's all kinds of communications about producing or not producing these documents, when and how.
Right.
And then when they're going through these boxes, the filter team, so I think there were 4 agents on the filter team and 3 lawyers on the filter team.
Right.
And the agents would go through the boxes and they would pull out privileged information, put the lid back on the box, and put the privileged information on top for the lawyers to look at, but not mark in the box where they
pulled it out. Right. And in a case like this, the location of a specific document can be very important, especially because the whole argument here is about, hiding the documents or taking classified out knowingly, and what it was next to might be of use, might be of value to the defense.
Right.
Because you're interspersing personal documents as well with this official stuff. So in that way, this is why it's considered to be spoliation, meaning that it's destroying the evidentiary quality of the evidence. And this is a problem.
There's no way to recreate for the defense where a particular document was in a box of documents, what subfile it might have been in.
Because of the way the Bureau handled them, not because of inherently how, chaotic the document box is. And I don't understand this. It's like in the old days that would not have happened because the agents would have put slips in, you know, they would have put a marker in that would have identified that this document was in between these other two documents.
Yeah,
And they would have put a divider, a spacer in there.
I think part of the problem was they wanted to do it all on site
Aha.
instead of as you would normally do, identify that it's got material in the box, seal the box, haul it away, do the
Right.
examination more deliberately
Right.
in another
And
location
not in a
over
hurried environment.
however
Yeah.
much time you need to do it.
Right.
Exactly.
Right. But there's still no excuse for not doing the dividers. I don't understand what could possibly could be other than that that's an old school technique and you,
Dumbass.
people don't know how to do
No,
it.
no, as I have described, it's called dumbassery.
Dumbassery. All right. Yeah. So,
Yeah. I got another point. If you from a step back from a distance and look at this, and if you view Judge Chutkin and Judge Cannon in Florida as playing cards across the table from one another,
uh-huh.
Judge
Long
Cannon
distance.
there's a joker in the deck, and Judge Cannon is holding it. Now, whether she plays it, who knows? But next week, she's hearing arguments on Ed Meese's motion to disqualify Smith,
Right.
special counsel Smith, because he was not
Lawfully appointed.
appointed. He was not appointed pursuant to act of Congress, and nor was he approved by the Senate. So he is acting as an officer of the United States illegally.
Ultra vires, lawyers would say.
So if she busts him, if Judge Cannon grants that motion, what does that do to Judge Sutton's case?
I don't know. Oh my. Well, I don't know what Judge Hutchin's going to think is going to do the case, is what I meant to say, because it would seem like how could you be indicted, right, in that scenario? Like the indictment couldn't possibly be any good. But I mean, if it's
No,
ultra vires, it's ultra vires.
it's a yeah. I think both legally, if that if that decision is made, question is, does it bind any other court in the country? Some court of appeal somewhere is going to have to weigh in on
King, did
that,
we
I think.
lose you?
I'm trying to talk. Can you hear me? No. Hello?
I can hear him.
Okay. I'm done. I said all I need to say. Pass that on, Ship.
Well, I have an early flight tomorrow morning, so I think maybe we should bring this to a close. Now I'm not hearing anybody.
Ship, can you hear me?
I can now, but I couldn't for a moment. Can you hear me?
I think, Ship, you and I can say good night, everybody.
Yep, I think it's time to go. We've been at
All
this
right.
over 2 hours, so I'm guessing it's going to be a longer version next week. So bring some snacks.
Okay. Good night, everyone.
Good night.